On July 1st, the three new criminal laws, Bharatiya Nyaya Sanhita, Bharatiya Nagrik Suraksha Sanhita, and Bharatiya Sakshya Adhinyam, came into force in India. It replaces the Indian Penal Code of 1860, the Code of Criminal Procedure of 1973, and the Indian Evidence Act of 1872. These three laws were introduced on August 11, 2023, in the monsoon session of Parliament when 97 opposition MPs were suspended due to the protest against the Parliament security breach. Then, Union Home Minister Amit Shah stated that these bills replace the colonial era rules that are completely unsuitable for this day and age. However, opposition and critics had pointed out that most of the content continued to remain the same in the three new criminal bills. Though the bills were referred to the Parliamentary Standing Committee on Home Affairs, the informed dissent of many members of the committee was not taken into consideration. In the new laws, organized crime and terrorism have been defined, and crimes like false promises of marriage, gang rape of minors, and mob lynching are covered. But along with it, there are also other concerns. The laws give more power to police and do not offer any protection to men if they are raped, among other concerns. With these new laws being implemented, the already overburdened judiciary will now face new challenges, along with the police, lawyers, and other authorities. Let us talk to the High Court advocate Anwar Ali to decode these new criminal laws and get a better understanding of whether they are government friendly or citizen friendly. Thank you so much, sir, for doing this with us firstly. And the first thing that we want to know is that earlier, when the three criminal bills were, which are now laws, when they were passed, one of the things that the critics had mentioned was that they don't have any major difference from Indian Penal Code or CRPC or the Evidence Act. Is it true? Is there a stark difference, or is it just similar to what was already there?
Well, thank you so much for this, and I'm grateful you have invited me on this platform. First thing, I want to make it very clear that these laws are not going to make any changes with respect to so-called colonial laws, etc. The statement which was used by Home Ministry that we are going to change the colonial laws. It's only a words. It's not actual in terms actually. Because basically, if we see the language which right now we are speaking is also English, which has come from the colony. So the act which was enacted to the effect when taking into the consideration of those times in those days have been in effect, and subsequently there have been number of amendments to them, and also the high courts and Supreme Court have reiterated, corrected, and made the subsequent requirements by giving the and framing the guidelines to the effects. Now, coming to the aspect of major changes, I would say if at all we were in requirement of a change is concerned, we have the example of constitution. We could have made the amendments to the effect wherever it was required. The whole change was not required. I would say it's just a time pass game.
Okay.
Merely because you want to change something, you could have made amendments to that effect. Instead of changing the whole scenario, you could have brought amendments wherever it was required. Now, entire sections are being changed.
Hmm.
I'm mentioning entire sections are being changed, not the sections. I mean to say,
That's right.
for example, say 498A, which is a famous section, or 420, famous section. The content of that section is as it is.
Hmm.
Only they have changed the section number. Instead of
So it's just
420, it's another section.
a change in the numbers, but the content, the law, the whole thing is
Remains the same.
still more or less completely the same thing. Only that there is a difference in the sections that
Yes, yes, yes.
people would have to remember now.
Yes,
That's all.
yes. No major changes. But coming to the BNS, there are some other aspects also which are not being covered, which are left out, which are going to have their own effects in the society. We will witness them in the coming days.
And what are these changes that you're talking about that have been left over?
Major change with respect to bringing the laws to the effect of consensual relationships, criminalization of consensual relationships. One, which affects directly to the person's life, and
Yeah.
the definition of unnatural relationships are not being established, which was mandated actually, because we are not living in such a city or situation or a society where everything is taken for granted.
Yeah.
Laws are made for humans, laws are not made for the animals. So when things are coming to the aspect of animal and human, both cannot be equated with one single provision of law. Everybody has their own laws, but laws are made to control, to manage, to maintain, to sophisticate the society to the extent of society according to the comfort of the human beings. Now I do not agree with the comfort of human beings, because laws means somewhere sometimes not to the will and wish of the person.
Hmm. Yeah.
Law means something
It's
which is not.
important for the society.
Yes, yes, yes. What is feasible for me and what is admirable for me, that cannot be a law. Law means you cannot murder somebody. You cannot murder means you cannot murder. That's all. Now, to that effect, you should have a provision, penal, which will control the society. Now, what has happened in BNS and BNSS? They have left so many places, which is going to hamper the society. One. Second, the criminal cases to the effect of a personal life, marital life are going to increase. Third,
Okay.
the relationship which was cut down are going to take the benefit of these criminal laws. However, we have witnessed so many cases with respect to 498A, 376 are concerned. The Supreme Court have made stringent and restricted rules in those things. They have stated that the usage of 498A or to the effect of POXO Act or to the effect of 376 rape is concerned, people are misusing them to the extent that the justice will not be delivered, and victim will be the person who is not actually the victim. The accused becomes a victim, and by whatever means he has to undergo the criminal justice. Now what happens because of this decriminalization and to the effect of criminalization with respect to, apart from the consensual relationships which are taken into consideration for the purpose of marital relationships which are not amounting to consensual relationships, now the matrimonial cases are going to increase to the maximum extent. What
Okay.
we are witnessing right now, it's going to maybe 10 times more. May not be today we will witness it, but in the
In the
next decade.
future, we might, yeah.
Yes, yes.
Also, human rights group Amnesty, they had mentioned that Indian authorities must repeal the new laws as they allow for police abuse. And you have also mentioned that there are many dangerous aspects of the three new criminal laws. Is it truly that will it truly allow for police abuse? The three laws. What does it say about the FIRs, police custody, judicial custody? What, because we see there are a lot of changes in these sections.
First, I would like to mention when the Indian Penal Code CRPC Evidence Acts were there. Now they have been repealed. When they were there, we have taken centuries to understand those laws. And it is not only the CRPC, IPC, or Evidence Acts which are said to be so-called colonial laws. So we do also have the Transfer of Property Act, which was also enacted in 1882. So merely because you just quoting one thing in another bucket, quoting another thing in different aspect to the satisfaction of yourself is not going to help. It's only going to spread the anarchy in the society. This first. Secondly, these laws, the criminal jurisprudence was divided into three aspects: one, minor offenses, heinous offenses, and economic offenses. These offenses were beautifully articulated by the Supreme Court in one of the cases I mentioned. It was held that the offenses which are punishment maximum to 7 years and below 7 years, they should not be arrested without giving any proper reasonable accountability. And that was decided in Satyendra Kumar Until versus State of versus CBI case. The guidelines were framed according to the and accordingly the provisions were made out. In that aspect, Arnesh Kumar judgment was there. which clearly mentions that wherever the family disputes are there, you cannot directly go and take them to the custody. You have to wait for it and you have to make a proper investigation. And to support that argument, there was another judgment from Supreme Court which states a Lalita Kumari judgment. These are famous known judgments: Lalita Kumari judgment, Arnesh Kumar judgment. And when a person is arrested, detained, when he is taken to the police station, and subsequently when he is brought to the judicial custody, what are the provisions to be followed? How he has to be taken into consideration? How he has to be given a proper
Treated, yeah.
relief, etc., is discussed in a DK Basu judgment.
Yeah.
Now, whether this BNS will be going beyond those judgments? First question. Secondly, the judgments of the Supreme Court or the High Courts are called as a court of record. Now, court of records cannot be taken for granted as any cause. Once the judgments are said, take for example, the Arnesh Kumar judgment says wherever the offense punishment for the offense is less than 7 years, not exceeding 7 years, they should not be arrested. They should be issued with a notice of Section 41 ASCRPC. Now, this is going to affect the BNSS or no? The big question. We do not have any clarity to that effect. Second, now courts will again have to involve themselves into interpretations, bringing guidelines, and again altogether new experiment. There are maybe there are possibilities that court may adopt the same judgments to these cases also.
New ones, yeah.
Possibilities are there. We don't know what the judiciary is going to opt to, but at present these are the difficulties which have to be taken into consideration, and this will, however, going to slow down the judicial process.
Yeah.
It means the pendency of cases will increase again.
So, when we say, firstly, I understand that our judiciary is extremely overburdened. There is lack of, already there are so many pending cases. And now we see that there will be two different systems that would work. Firstly, the new laws will be implemented to the new cases that have started from July 1st. And before that the cases were ongoing, they are going to be based on the Indian Penal Code, CRPC, and Evidence Act. How is it going to function? And as lawyers, judges, police, what's the changes? What is it going to be like for them to adapt to? Because these cases are constantly happening, they haven't come to an end. So how is it going to happen now?
That is what my concern was. I stated with referring to the judgments, DK Basu, Ganesh Kumar, Lalita Kumar or Satyendra Kumar until etc. They have got their guidelines to the effect of how the police has to function, how the person who is taken into custody has to be operated, how the person has to be brought before the magistrate, how that person has to be taken to the police custody, to the judicial custody, and what is the limitation, what is the extent, how he has to be kept into. But now all of these are going to be at stop. They will be like at I would mention, I mean, a pause kind of a situation. Everything is now paused for a while. Now again it has to start. Now,
so again we might see the same thing being repeated, or if the court comes up with something else than that.
Probably the previous cases which are pending before 1 July 2024 will be dealt according to CRPC, IPC, and evidence. Now take for example, the incident happened on previous to the 1/7/24. Say for example 15/6/24. Case is registered after 1/7/24. Now whether IPC will be applicable or BNS will be applicable, because the cause of action is previous laws. Action will be taken on the new law.
Based on the new law.
So these confusions are also there, which are to be clarified.
So these are something that's still going on, and probably all the authorities that regularly deal with these, they are still facing it. Has there been any training or work that has happened that that has seen to be as a solution for these things? Because these are very immediate problems. Is there a solution to this?
Solution is we have to adopt it for now, continue with the process, how it is going to, how the judiciary is going to take it. We being advocates, we can only put up our grievances before the judges, make the protections against this, and make representations to the state. to take into consideration. Apart from that, it is now the burden is upon the judiciary, upon the High Courts and Supreme Court to consider and interpret them, guide and frame the new guidelines or to adopt the new previous guidelines. Now it is all left to the High Court and Supreme Courts.
Right. Also, what now let's come a bit to the everyday things that might happen with a common man. How is the registration of the FIR going to be filed in these, as per the new
Previous
laws?
laws, the day a person lodges a FIR before the police station, on same day, same time, the FIR was supposed to be registered. It is according to the guidelines of the again Supreme Court. Now, in new law, a 15 days gap is given. Now it is at the discretion of the police officer whether to register or not to register. He will start with an investigation. If he finds it necessary that yes, it has to be registered, on finding of prima facie material, he will register it. Otherwise, chances are there that a person will not get FIR registered in his favor. So previous and new, a drastic change, but it is going to be, hamper the justice.
So the police official can say that we don't have to register an FIR based on their interpretation, their understanding of the complaint and the
No,
case.
the law itself provides them 15 days time to register the FIR.
File a complaint, yeah.
Yeah, register the FIR. And subsequently, when a person is now, see, in earlier cases, maximum 14 days police custody was given for interrogation, etc. But now it has gone up to 90 days. So you believe that your fundamental right of liberty is restrained directly from 0 to 90 days. You will not have the option to opt bail unless and until you are given to the judicial custody. So 90 days, no bail, nothing. Only after 90 days, when the person is given to the judicial custody, then he can seek for bail. So how draconian it is need to be taken into consideration.
And what about arrest warrants? How is that going to affect?
Same process.
Same
the moment the FIR is registered,
yeah,
the person has to be taken into custody based upon the offences, the classification, etc., etc. Again, time and again, these laws are directly or indirectly contradicting to the guidelines issued by the Honorable High Court and Supreme Courts. Because Honorable Supreme Court says the moment FIR is registered, if the category of offence is to the effect and the punishment is less than 7 years, he should not be arrested. He should be given an opportunity by issuing a 41 notice. But now, how it is going to be affected, how he has to be taken into custody, all these clarifications are yet to be awaited.
So this means that police abuse or abuse of power by police can increase in the coming days. Can it?
Not can increase. It has already increased.
Yeah, like
it has already increased. We are heading towards police state.
Okay. And also, now let's talk about a bit very specific problematic laws. First thing is that Section 69 of the BNS has raised concerns about potential misuse. So, what are your thoughts on the provision that criminalizes sexual intercourse based on deceitful promises of marriage, and how might it be misused also?
In my initial talk, I said there are more chances of misuse of law with respect to 376 POCSO and also 498. I referred to
the marriage.
Now 69 is nothing more or less to the effect of 376 or POCSO.
Yeah,
no much difference. The difference will be like in earlier 376, it was specifically mentioned, and we have number of judgments of Karnataka High Court which states that the false promise or promise to marry has ended up in something is not rape. There is a relationship of consensual relationship. When the consensual relationship has lasted for long years, now coming to the point of break or promise of marriage is another aspect. And there we also have a judgment which says that if a person who has literally promised to marry, but due to the elders of the family who did not fulfill it, that is also not a rape. So when two minds are meeting together with the same consent, same concept, and if they have indulged into physical relationships, those are not offenses to the effect of 376. Now coming to 69. 69 says about promise of marriage,
Yeah.
two people coming together, but his intention is not to marry.
Yeah.
It's a predetermined.
Hmm.
My intention is not at all to marry, but I just want to entertain somebody for some time, for some purpose. Those relations, take for example, live-in relationships are there, live-in partner, so many words are there.
Yeah.
So those relations are going to take the benefit of this section. If either of the partner is not willing to
Mhm.
marry, then certainly it's going to take the benefit of BNS section 69. So you will see number of cases increasing. Mark my words, today we have less marriages, less marital institutions today, more live-in relationships. So by this, the institution, a beautiful institution of marriage, is day by day getting into diminishing way, and the relationships, so called as a live-in relationships, are increasing day by day. So when the marital institutions are getting decayed, the live-in relationship are at its rampant increase, then definitely the rampant increase of section 69 will be at play.
Okay. Also, one thing is that BNS does not include Section 377, or for that matter, any other section that will deal with the rape of men and transgender persons, also animal abuse. Now, because this new bill excludes them, new law excludes them, making so now it's like rape of men, transgender individuals, and animals will not be punishable by law. So, what is going to happen in such cases?
Now they have come up with an alternate section of section 75 with respect to sexual harassment
Hmm.
in BN. Now that won't much specifically speaks about unnatural sex. Um, Take for example, if a person, now in India, the the adulterous relationships are also being allowed. If a person out of marriage goes somewhere, that is not an offense anymore. However, the unnatural sex also includes, apart from the human beings, that includes animals. Now to that effect, there is no specific section which mentions, and
Yeah.
377 is supported by section 75 of BNS, but that section 75 of section
It's not
BNS
added. Yeah.
doesn't clearly mentions as to what is to be called as a unnatural sex.
Hmm.
So it's again under dilemma. Now if somebody lodges a complaint with respect to unnatural sex, then under which provision of law in BNS that has to be registered is under question. We need to have clarifications on those things in the coming days.
So as of now, there's no clarity
No
if such
clarification,
things happen.
no clarity at all.
Also, one thing is that the BNS, it aims to make sexual offenses gender neutral. We have seen sections where it has used the term gender neutral. How do you view this shift, and what impact do you think it will have on the prosecution of such cases?
No, using the term gender neutral is a different one, and punishing a person on the concept of gender is another aspect. Now, if you take a consideration of section 498A in the previous IPC, now it
Yeah.
has come up in, maybe at, if I'm not wrong, section 84 or 85, section 85, husband or relative of a husband of a woman subjecting her to cruelty. Now, this is again an step ahead of 498, which clearly mentions a husband or a relative of husband of a woman subjecting her to cruelty. Whether they have used the term a wife or a relative of a wife subjecting husband to cruelty, no, I don't see anything of such sort.
It's
So
more
it's
or less the
just a
same again. And just they've
sorry.
tried, it's more or less the same still, and yet they have just tried saying gender neutral.
एक जुमला होता है.
Also, one more thing is that the BNS has defined terrorism for the first time. in the Indian law. How significant is this definition, firstly, and what changes is it going to bring in the cases that are related to terrorism related offenses?
We already have UAPA, we already have
Hmm.
NSA. It was not necessary actually.
Okay.
It was not necessary. Already we have it. But the scope and broader aspect of
Hmm.
section which they have now come up with is it has got a great repercussions in the society. An individual is also referred to an terrorist.
Okay.
An individual is also referred to an terrorist to the subject of some definitions. Now this is like I don't want this person.
Hmm.
The state says I don't want this person. I want to eliminate him from the society at any cost. Now that person will be brought into that particular section. Say for example, if I am or you are resisting to the policies of the government,
Hmm.
you can easily be tagged as a terrorist. It is as simple as that. Say it another version of sedition.
Mhm. Also, sedition, coming to that.
Yes, yes, yes.
Uh, Here, the Home Minister and repeatedly they've said that sedition has been taken out under the new laws. But we also see that more or less the aspect of the sedition is still
The
there
difference
in
between
different
black
laws.
and gray.
Yeah. So, what what is sedition here in these new criminal laws, and has it's not changed? We don't really see a
It's a
change there.
blanket punch. It's a
But yeah,
blanket punch.
so
It's
are
a
we going
blanket punch.
to
Yes.
see more cases
More
happening?
or less. Just uh, merely because you have used a different term,
Mm,
but the intention remains the same.
mm.
So it's not going to
This
help. It's certainly a sedition.
and so are we? Civil society has raised continuous concern, at least under the Modi-led government, that students, opposition leaders, anybody who is opposing the government has been arrested under Draconian laws like UAPA, PSA. There has been a lot of issues on that. Are we going to see that more cases of this will be happening in the country then?
If we see the framework of the law, which has been
Yeah.
enacted right now, it's more or less, or say at one sidedly, going to help and support the state. It's not a citizen friendly act, it's a government friendly act.
So whoever is at the power may be able to use it.
Yes,
And now the states like Tamil Nadu and Karnataka, Tamil Nadu has formed a committee. They have said that they want to amend the laws as per the states of thing. And Karnataka Law and Parliamentary Affairs Minister H.K. Patil, he also said that they want to make 23 to 25 amendments to these laws before applying it. Is it possible? Are the states allowed to change, amend these laws?
states have got their state subjects. We have three category of
Yeah,
subjects: central, state, concurrent lists.
yeah. So,
So wherever the state has made its laws to the effect of a state government is concerned, it is at its discretion and at its majority. Now, once the central laws are enacted, the state cannot oppose it. Firstly, second, if it is opposing it, it can make more or less only the suggestions, but cannot repeal it. The central laws prevail over the state laws, just like the constitution prevail over everything.
yeah.
The same concept. The central laws prevail over state laws.
Hmm.
So state cannot amend laws made by the central government. It has to adopt it. Yes, they may make suggestions, they may seek for suggestion, they may seek for some alterations, reiterations, etc. But they cannot completely remove it.
Implementation might, we are not sure about it. Suggestions can be given, but
Yes.
applying it
Again, it's at the
would
discretion
be
of the central. The central is having the power to make laws. So once central makes laws, it has to be applied across the state, including Jammu and Kashmir.
yeah. So even now, if the, let's say if the states Tamil Nadu and Karnataka, they suggest the amendments, now it would be completely up to center whether to accept it or reject it. But in real, they might have to still apply the same laws.
Except option of suggestion, no other option.
Okay. And can these these new laws be reintroduced in the parliament? Is it possible? Because right now, I think a few days ago we saw that lawyers were protesting, and there had been a civic society has raised a lot of concerns about these things.
We have an example of farmer laws. Farmer laws were executed, brought into force, and subsequently they were meant to be taken back. Possibilities are there.
So there are chances that this
Yes,
can be
when it has
reintroduced.
enacted, yes, central government can take back also, and some petitions are pending before Supreme Court also for
Yeah,
taking into consideration of these
yeah.
draconian laws. So let's wait for the Supreme Court's hammer.
So after that, only we can know that what's going to happen.
Yes, yes. We are at
And
discussion
lastly,
stage, not at enactment stage.
what are some things that a common man should know? Maybe let's say about their rights. We've spoken about arrest and those, but other things that a common man should know about these new laws that might really be helpful for them.
Law says ignorance of law is not an excuse. Every person is bound to know what are laws. They cannot say that I'm not aware of laws. This is first. Secondly, it is a practical truth that not everybody know everything about law.
Yeah.
It is bounded duty of I being an advocate, you being a journalist, and we all people who are connected to the law, we should come up with such programs so that a layman can become a lawman.
Yeah.
It is our bounded duty to spread some messages to make people informed about the laws. So burden lies upon us, me and you.
So, any ending note for anything that you would say that common man should know about at least this one? Like we know about our fundamental rights, like at least right from school that's been introduced. That you should know these things even if you don't know the intricacies of the fundamental rights and duties. Anything in particular that people should know about the three new criminal laws?
Complaint, FIR, custody, judicial custody. That's all.
Okay, thank you so much for that.